Tison vs. CA and Teodora Domingo. GR number 121027, July 31, 1997. This case involves a property originally owned by spouses Martin Guerrero and Teodora de Zola Guerrero. Teodora died without ascendants and descendants, leaving only widower Martin and petitioners, niece and nephew, as heirs. However, Martin executed an affidavit of extrajudicial settlement adjudicating unto himself, allegedly a sole heir of Teodora. Later he sold the property to Teodora Domingo. When Martin died, the niece and nephew of Teodora as petitioners filed an action for reconveyance of the land and apartment seeking to inherit by right of representation. During the trial, petitioners presented documentary evidence such as affidavits, birth certificate, family photos among others, attempting to prove filiation with the deceased Teodora, but only the niece petitioner was presented as the lone witness. Private respondent Domingo filed a demurrer to plaintiff's evidence alleging, among others, that the affidavit is inadmissible for being hearsay, since the affiants were never presented for cross-examination. The lower court granted the demurrer to evidence, declaring that the documentary evidence presented are all inadmissible and insufficient to prove and establish filiation. The Court of Appeals affirmed the RTC decision. Hence, this appeal issue whether or not the petitioner's evidence was inadmissible, being hearsay to prove pedigree. The court held in the negative. The evidence were admissible since the evidence falls under the exception to the hearsay rule. As to issue on legitimacy, there is presumption of legitimacy that children born in wedlock are legitimate. And well settled is the rule that the issue of legitimacy cannot be attacked collaterally, such as in this case, in an action for reconveyance. Assuming allowed, the burden lies on private respondent, who is disputing the same. Hence, when private respondent opted not to present countervailing evidence to overcome the presumption, by merely filing a demurrer to evidence instead, she in effect impliedly admitted the truth of such fact. As to admissibility, while the documentary evidence submitted by petitioners do not strictly conform to the rules on their admissibility, an objection to the admission of evidence on the ground of incompetency, taken after the testimony has been given, is too late. As to weight of the evidence, the primary proof to be considered in ascertaining the relationship between the parties concerned is the testimony of the niece petitioner to the effect that Teodora, in her lifetime, categorically declared that the former is Teodora's niece. Such a statement is considered a declaration about pedigree, which is admissible as an exception to the hearsay rule, subject to conditions 1, 2, 3, 4. There is no dispute with respect to the first, second, and fourth elements. Nevertheless, the third element provides for an exception, as this requirement does not apply where it is sought to reach the estate of the declarant himself, and not merely to establish a right through his declarations to the property of some other member of the family. The declaration of Teodora that petitioner is her niece is admissible and sufficient without need of evidence aliundi. Such declaration is rendered competent by virtue of the necessity of receiving such evidence to avoid a failure of justice.